Hello everyone and welcome to this video tutorial on economic duress in contract law. Economic duress in contracts occurs where a party to a contract threatens to cancel a contract unless the other party agrees to their demands. The economic duress occurs when the other party is stuck as there are no other practical options but to agree to the new terms of the contract. In this way, then, duress in contract law relates to where a person enters an agreement as a result of threats. Where a party enters a contract because of duress, they may have the contract set aside. Originally, the common law only recognised threats of unlawful physical violence, but in more recent times, the courts have recognised economic duress as giving rise to a valid claim. In order to have a contract set aside on the grounds of economic duress, 5 conditions must be satisfied. Firstly, pressure must have been exerted on the contracting party. Secondly, the pressure was illegitimate. Thirdly, the pressure induced the claimant to enter the contract. Fourthly, the claimant had no choice but to enter the contract. And finally, our claimant protested at the time or shortly after the contract was made. As usual, we're going to have a look at each of these in turn with a case that helps to illustrate the point. First requirement for proving economic duress was that pressure was exerted on the contracting party. In the case of North Ocean Shipping, which is sometimes just known as the Atlantic Baron, a contract was made to build a supertanker for an agreed price. The seller then refused to complete unless the buyer promised to pay an extra 10%. The buyer, because he didn't really have any choice, agreed and made the payments because this ship was needed to fulfill a contract that they had with someone else. So the court held here that there was economic duress because pressure was put on the buyer to pay these extra payments. Secondly, the pressure needs to be illegitimate. And it's difficult to distinguish between an illegitimate and a legitimate pressure because there is expected to be a certain amount of pressure in commercial bargaining. That's the nature of business. What we've got to illustrate this is Atlas Express and CAFChem. Here, the claimants had a contract with the defendants to deliver baskets to Woolworths, which the defendants manufactured. The claimants underestimated the size of the baskets and they therefore ordered the defendants to pay more. Now, the defendants would have gone bankrupt if they'd not delivered to Woolworths, therefore they agreed to the higher price. And it was decided in this case that Atlas could not enforce an agreement to pay a higher price, which had been agreed because of illegitimate pressure. The third requirement is that the pressure induced the claimant to enter the contract. And it might well be that there has been some pressure, but the claimant would have entered the contract anyway. So that's the situation that we're trying to avoid here. So we've got the case of Barton and Armstrong from 1976. Facts were that Armstrong made a number of death threats to Barton to pressure him into signing an agreement to purchase Armstrong's shares in a company at a substantial overvalue. Barton agreed to this partly due to the death threats, but also another reason for signing the contract was due to the fact it would mean that Armstrong would no longer have the controlling interest in the company. Now, what the court said here was that a contract could be set aside where death threats had been received, and obviously that seems fair enough, and they said that they were at least one cause of entering into the contract. So although there were a couple of reasons this contract was signed, firstly the death threats, and secondly so he wouldn't have a controlling interest, the death threats were certainly one cause and that's enough. So the pressure doesn't have to be the only cause for the claimant to enter into the contract. That's what we're seeing here. The fourth requirement is that the claimant had no choice but to enter the contract. And this is illustrated in the case of Universal Tank Ships. The facts of this case were that the International Transport Workers Federation blocked the claimant's ship and prevented employees from leaving the dock unless they signed new contracts. These contracts were signed, but they were later held to be void through duress, because clearly, if you're told you can't get off the ship unless you sign it, you've clearly got no choice but to enter the contract. So fair enough for those contracts to be set aside there. The final requirement for proving economic duress is that our claimant protested at the time or shortly after the contract was made. And just bear in mind here that the claimant may not be able to protest at the time of the threat because A, they might be scared, or B, they might obviously feel the pressure that they've got to go along with it. But we do want them to protest at least shortly afterwards. So we're going to look again at the same case from the start here, the Atlantic Baron, where a contract was made to build a super tanker, and the seller then refused to complete unless the buyer promised to pay an extra 10%. The buyer's agreed and has made the payments because the ship was needed. But what's important for this rule here, for rule number 5, is that our claimant protested about the extra payments shortly after the contract. He didn't protest at the time because obviously he needed this super tanker, but as soon as was practical, he protested about this contract. In summary then, we can have a contract set aside because of economic duress. But in order to do so, we need to prove these 5 requirements: that there was pressure exerted, the pressure was illegitimate, the pressure induced the contract, the claimant had no choice, and the claimant protested at the time or shortly after the contract was made.